So we are so excited that you guys are here today and excited to share what you have. So thank you, and I'll just let you take it, Tom. Thank you.
Okay, well, thank you very much, Tanya, and good afternoon. For the next 45 minutes, 45 minutes, we're going to be talking about probably the two most important documents that you should have as you prepare for long-term care, as you prepare for the senior years. I'm going to be talking about the power of attorney, the financial power of attorney, and Mike is going to then follow up and talk about the Advanced Healthcare Directive. With the power of attorney, what I'm going to be talking about is why you should have a power of attorney, what could happen if you do not have a power of attorney, what your power of attorney should include, and that the power of attorney should be kept updated and revised regularly. Then we're going to, Mike, after I finish with the power of attorney talk, Mike is going to talk about the Advanced Healthcare Directive and the post forms, and we're going to reserve some time for questions. So if you have questions, write them down. We'd be happy to address those questions at the tail end of our presentation. Now, when talking about a power of attorney, I want to start out by telling you about Ruth. Ruth was a client of ours, but Ruth's not her name, of course. We've changed the name to protect the innocent. But I visited Ruth out in Pearl City a while back, and she was delightful. She was there with 5 other ladies. They were having lunch, and they were enjoying themselves, and it was just a very pleasant visit. Not the case about 5 years prior to that. Let me tell you what happened. About 5 years prior to my visit to Ruth at Pearl City, I was in my office and I got a call from an assisted living facility in Honolulu. And the reason they called me is they had found my name on some documents. I had done some estate planning documents for Ruth, maybe 10, 15 years prior to that. And they found my name on the documents. They called me and they told me that Ruth was paying the bill. The bill for the care facility was being paid for by Ruth's daughter. And by the way, it was $10,000 a month for this care facility. And it was being paid for by the daughter through a power of attorney. The daughter had become incapacitated and was no longer able to pay the bills, pay the caregiver, the care facility's costs. So they asked if I could come down and visit with Ruth and do a new power of attorney, maybe name her nephew as an agent. And because the power of attorney that Ruth had did not name an alternate agent, it just named her daughter. The daughter was no longer able to function in that capacity. So I said, sure, I'll come down and I'll talk to Ruth and we'll see if we can do a new power of attorney. They did tell me that they were a bit concerned that she might be going into that she might have on-stage dementia, but it hadn't been diagnosed. And so anyway, I thought I'd go down and visit her. So let me tell you a little bit about what a power of attorney is, and then I'm going to get back to telling you what happened with Ruth. A power of attorney is a written document. It's a legal document, and it gives the authority to another person, an agent that you select, to be able to speak for you, to step into your shoes, and to basically manage where you're not able to manage. A power of attorney is very important. In fact, the power of attorney is like the key that opens the door if you become incapacitated. Without the power of attorney, we're going to talk about the problems that can come up. So, but the first thing you do when you do a power of attorney, you want to be very careful to properly select an agent that can act on your behalf. That agent should be reliable. That agent should be trustworthy. That agent should have good judgment. That agent should be available. The agent should have the time, the energy, and the willingness to be able to do the job. And so we want to make sure that when you select a power of attorney, you select an agent. Many people will select their spouse. If they're married, they'll select their spouse to be their agent or one of their children. But there are some local companies here in Hawaii that will also serve as agents. Maximum Legal Services Corporation, Legacy Company, and CSI. That's Comfort, Security, and Independence. They will serve as agents also under a power of attorney. Now, you can have more than one agent. You can have multiple agents. You can have agents in succession. That could be one agent, and if that agent can no longer serve, Lori, if you could move on to the next slide, the agents can be co-agents. You can have two agents on the power of attorney, and then you decide and state in the document whether you want those agents to have to act unanimously together or each one be able to act independently or separately from the other. Or if you only want one agent, you should always have another agent as an alternate, a standby, in case the first agent can't serve. That was the case with Ruth. Her daughter was no longer able to serve. There was no succession and no alternate named under her power of attorney. So now the power of attorney can be limited or it can be general. If we go to the next slide, generally, you can select a limited power of attorney is for a specific purpose. A limited power of attorney might be just to sell real estate. A limited power of attorney might be just to access a specific bank account or a specific brokerage account to pay bills. Or the power of attorney could be general. General means basically that the agent can step into your shoes and do everything that you could do. Okay, so it can be either currently a power of attorney, in addition to being either limited or general, can be currently effective or springing. The next slide, we identify that the current power of attorney becomes effective as soon as you sign it. As soon as you sign it, it's in effect. The springing power of attorney only becomes effective if the spring is sprung. Now, what does that mean? A springing power of attorney might say, this power of attorney only becomes effective when and if I become incapacitated as determined by my medical doctor, my PCP, or maybe somebody else that you've designated to make that decision. So the power of attorney is dormant, basically, until the spring is sprung, that the medical doctor makes the determination and power of attorney then becomes effective. You can have it either way. So why should you have a power of attorney? Well, because of the risk of incapacity. As long as you have capacity, you sign your own documents, you manage your own affairs, you pay your own bills. But if you become incapacitated, you need to be prepared. You need to have somebody that can step into your shoes and take care of all of the decisions, pay the bills, and manage your financial affairs. So let's get back to the Ruth story. About 5 years prior to my visit to Ruth out in Pearl City, and I was back in my office, and I told you about the call I got from the assisted living facility in Honolulu. So I went down to visit Ruth. I went into Ruth's room. Ruth needed assistance with activities of daily living, with some of the activities of daily living. She was in a wheelchair, but when I went into her room, she was kind of confused. She didn't recognize me. Of course, I hadn't seen her in 10 years. She didn't know who I was. She didn't really understand what I was talking about when I was talking to her about maybe redoing her power of attorney. And she didn't seem to be able to hear me very well. I had to talk loudly, and it was really kind of I just began to realize that I wasn't going to be able to do another power of attorney for Ruth. What I was going to have to do, probably I got back to my office and I thought, well, perhaps the only thing that I can do is maybe apply, go to court and apply to have a conservator or a guardian appointed to manage Ruth's affairs. That would have been unfortunate. It would have been time consuming and expensive. So why should you have a power of attorney? Well, that is one of the reasons why you should have a power of attorney, to avoid a conservatorship. If you don't have a power of attorney and you have assets and decisions that need to be made, family members, somebody has to go to court, and that can be a 6-month delay. It can be expensive, attorney's fees and so forth. And even if you have a trust, there may be substantial assets that are not in the trust. Your IRA, for example, is not in your trust. To be able to access the IRA to pay bills, you need the power of attorney. And if you're incapacitated, maybe as a result of an automobile accident, you need somebody to be able to talk to the insurance carrier. So, or to apply for insurance. You have long-term care insurance. You need somebody that has authority to apply for that long-term care insurance. So you need somebody with authority to deal with the caregiver agencies. Bring somebody in to help manage your care at home, or to get you into a facility that's more appropriate where you can be properly cared for. So the agent can speak for you on your behalf to your bank, to your insurance carrier, and to caregiver agencies. Your agent will have immediate access to financial accounts and to be able to pay your bills. So getting back to Ruth's story, I got back to my office and we thought, well, we're going to have to go get a conservatorship for Ruth. We had an elder care coordinator in our office at that time. This was prior to Mike. You're going to hear from Mike a little bit later. This was prior to Mike. This was Sue. Sue said, well, before you go to court to get a conservatorship, let me go out and talk to Ruth. Let me go out and look at her situation, and maybe we can come up with another alternative. So our elder care coordinator, Sue, she went out to visit with Ruth, and she discerned from looking at Ruth's medical records that maybe Ruth was being over-medicated for an epilepsy problem she had had since she was a child. Also, he discovered that nobody had thought about changing the batteries in Ruth's hearing aids. So she talked to the PCP, and they changed the medications. And about a month or so later, I went out to visit Ruth. And let me tell you, I went into Ruth's room, and she looked at me and she said, well, Tom, it's been many years. Your daughters must be grown by now. She knew who I was. She remembered me. And we had a nice conversation. And I was able to do another power of attorney for her at that time. And let me talk a little bit about some of the clauses that we wanted to include in a power of attorney, and that you should consider thinking about when you do your power of attorney, when you meet with your attorney. There are certain clauses that you might want to, especially as you're aging, as you're maybe entering the final lap. You want to make sure there are certain clauses in your power of attorney that could be helpful. One of those is to be sure and select a successor agent if the original agent can no longer serve. That hadn't been done in Ruth's case, and that's what had caused the call to me to begin with. Another power may be to give the agent authority to take specific actions to qualify you for government benefits, to qualify you to accelerate the qualification for Medicaid, for example, such as spending down assets, purchasing non-countable assets, moving countable resources into an income stream. Now, we're not going to go into much detail on this. In fact, we're not going to go into any detail on this because we have a whole seminar devoted solely into qualifying for Medicaid. But the authority to do that should be given to the agent in the power of attorney. We also want the agent to have authority to pay for a higher quality of care for you. If you're in the hospital, if you're being cared for at home, or if you're in a nursing home or at an arch, we want to be the agent to have authority to be able to do some things to bring a higher quality of care, such as getting you a separate room, such as authority to do dental care, hearing care. Dental care isn't provided for by Medicaid. Well, the agent, under the authority of the power of attorney, could do additional things to provide for your care, and maybe even bring in a supplemental caregiver. Some of the agencies are understaffed, and the agent should have authority to bring in a supplemental caregiver. The agent under your power of attorney should also have authority to sign a HIPAA release so that medical information can be disclosed to the appropriate people that are involved with your care. The agent should be required to give periodic accountings to other family members that is very important because it helps with transparency and accessibility. I missed the reverse mortgage. Agents should be able to have the authority to apply for a reverse mortgage. Why get a reverse mortgage? Well, if you're living at home and you're starting to run low on finances, the agent should be able to have authority to to use the equity of your home to continue to provide you with long-term care, so you can stay at home and have the care paid for through the use of a reverse mortgage. So then we go on to the agent making periodic accountings to provide transparency and accountability to your other family members. And the agent should also be given authority, or could be given authority, to set up a revocable trust for you and transfer your assets into that trust so as to avoid probate at the time of your death. Now, some of you may already have a trust. If you already have a trust, you still need the power of attorney. Why? Because there are a lot of assets that you don't put into your trust. For example, one asset might be your IRA. You don't put your IRA into your trust, but it may have the money in the IRA that you would anticipate being used to provide for your long-term care. Well, you need an agent outside the trust. Trustee doesn't have the authority, but the agent under your power of attorney can be given the authority to access your IRA so as to be able to pay for your long-term care, and to also make contact caregivers and arrange for in-home care or for care in a foster home, to work with your insurance company if there's an insurance claim. The trustee can't do that, but the agent under a power of attorney can do that. In fact, I remember some years ago, I had a trust company call me. They had a client that had a substantial trust. Most of it was real estate, and he needed assistance with long-term care. They needed liquidity. They needed money. He had a lot of money in his IRA. He didn't have a power of attorney. Oh, we had to go to court and get a conservator appointed just to get access to his IRA to pay for his long-term care. So word to the wise, even if you have a trust, you still need that power of attorney. When you have a trust and you have a power of attorney, one of the clauses you might consider for that power of attorney is to give the agent the authority to sign your resignation as trustee or to appoint a co-trustee of your revocable trust. Why do that? Well, if you become incapacitated, this saves a lot of time and expense of having to go get a physician to establish that you're incapacitated so as to take you out as trustee of the trust and put the successor trustee in authority. You get the successor trustee into authority under the trust agreement. You could give the agent the authority to remove you as trustee or sign your resignation as trustee. Finally, you should arrange to have the power of attorney and of trust, if you have the trust, regularly reviewed. Now, you recall our situation with Ruth. If Ruth had named a successor agent in her power of attorney, if Ruth had the perfect power of attorney, all the right clauses and everything set up properly, we still would have had the problem because they would never have called me. The caregiver agency that she was at would never have called me because they wouldn't have needed to. There was a successor agent under the power of attorney. So you have to have the agent, you have to have a regular review of the power of attorney and a regular review of our client. So we've established maintenance programs to continue that. And Mike will be talking about that perhaps. That's why we have an elder care coordinator. That's why we have a Mike on staff to be able to regularly keep contact with our clients so that we don't run into the problems. We may have the perfect documents, but they need to be regularly reviewed to make sure they're kept up to date. So I want to give you a couple of takeaway points. Number one, have a well-drafted, comprehensive power of attorney that covers all the bases that we've just talked about. Secondly, name an alternate agent in that power of attorney. And thirdly, have that power of attorney reviewed regularly, because there could be a change in the agent status. There could be a change in your capacity to be able to make changes. Now, if Ruth had done the first two of these, had a will-drafted power of attorney and an alternate agent, that would not have solved her problem. Her real problem was the Medicaid issue, and that would not have been resolved. It may never have gotten resolved unless you also have the third takeaway, which is to have the power of attorney regularly reviewed because of possible changes in yourself, in your own capacity, and in the agent status. So that brings me to our elder care coordinator, Mike. Mike is going to now talk to you about the Advanced Healthcare Directive and the value and the reason why you should clearly have that, one of the most important documents in preparing for long-term care. Mike, take it away.
Thank you, Tom. Good afternoon, everyone. My title in our scope of service is an elder care coordinator. I am a certified case manager. I've been a nurse for about 30 years, and I've been doing community case management for the last 10 with a focus on our kupuna. I'm going to talk to you about the medical side of this equation. Tom was talking more in relation to assets and finances and those sorts of things. I'm going to tell you a real short story about a client we have worked with that had a stroke. She had no healthcare directive, no power of attorney. Her sister and 2 adult daughters lived on island. One of the daughters had autism and needed supervision. After the stroke, the client had no physical problems, could still walk and talk and bathe and feed herself, but she had problems with cognition. She could not give her date of birth, had trouble with numbers, couldn't manage her finances or drive, couldn't coordinate her care. Short-term memory problems, trouble with word finding, could have some simple conversations. Fortunately, we were able to meet with the family, and she had enough capacity to appoint her medical agent. And after that, we were able to assist in finding her a safe place to live in a care home. So her situation was kind of, I guess you could call it a disaster scenario, because without a power of attorney and a medical agent, what would she have done? So something to think about. So an Advanced Healthcare Directive is commonly known as a living will. You document giving authority to someone to help you manage your health if you cannot manage it yourself. So one of the important things to point out about the Advanced Healthcare Directive is it doesn't, the agent doesn't really have any power to make decisions for you unless you're incapacitated. Next slide, please. So it covers preferences you may have to artificial nutrition, hydration, CPR, those medical issues. Next slide. And you can include treatments that are wanted or not wanted. You can even say where you prefer to get your health care, and you can document your religious or spiritual preferences. Next slide. And Hawaii actually allows you to identify that you have a health directive on your state identification. Next slide. What if there is no health directive? So this unfortunately does happen. I don't know how often in the hospitals, but it does happen. Generally, if there's no documentation of a health directive, the medical team will look to the spouse, if they're married, for help with medical decision making. And if there's no spouse, they will usually talk to children. There's no children, maybe they will talk to siblings of the patient. But if there's no documented directive, oftentimes family members will get together and they'll be asked to appoint a surrogate to make the decisions. Next slide. Now, this is also interesting because you can put on your healthcare directive, no CPR, you want this, you don't want that. And then if you don't document your wishes regarding artificial nutrition, also referred to as tube feeding or hydration, that medical agent that you identified could make those decisions without that being written on paper because it wasn't addressed. So usually the agent that you identify will know what your wishes are, and typically you pick somebody who has your best interests in mind. Next slide. But without the directive, decisions can become more difficult. And the family is already going through a rough time. So for there to be disagreement and disputes about what mom or dad would or would not have wanted, it just makes the situation so much more stressful. Next slide, please. And this paper does not say, I don't want any medical treatment. That's not the purpose of it. It can say that, but just having one doesn't mean you're not going to get medical treatment, because you can document what you want and don't want. It doesn't matter what your age is, it's good to have a healthcare directive, because we can't pick when our time is going to come, and accidents and illness affects everyone. And there are, if you go back into the history of this documentation, this advanced healthcare directive, it is legislated by the state. So each state has a slightly different law. But these came about because of those right to die cases involving those individuals, some real unfortunate circumstances. Next slide. So as in the power of attorney, it's good for you to name an alternate. Because sometimes the person who you identified as primary may not be well enough to make decisions, so it's good to have an alternate. And most importantly, it's good for you to have a discussion so that the person knows that you name them as your medical agent. You don't want them to be surprised. You will want to pick somebody who you have a relationship with so that they understand you. Close friends, a doctor, a clergy member could be your agent. Next slide. So there are a couple of tools available online. You can see the Conversation Project and Your Way Workbook and 5 Wishes. Those are all ways to document your decisions and your thinking. It's kind of hard sometimes because there are some cultures who feel that you're not supposed to talk about death, and it's bocce for some families, but maybe you don't need to talk about dying. Maybe you need to talk about who thinks the most like you and who could help make decisions. That's one way to start the conversation without actually talking about incapacity and death. Next slide, please. So would you want to have a copy for yourself and give a copy to your agent, your primary doctor? Hospitals that you frequent will file one for you if you bring it in for them. It's good to review it and update it, just like your trust and your will, because things do change in your life. Oftentimes, medical providers will ask you if you have updated your health directive before surgery. And, I often hear people say, Doc, are we going to have a successful surgery? Because you're kind of worrying me with this talk here, but you never know what's going to happen with anesthesia, so it's always a good idea to review it. Next slide. So if you haven't seen this green form, it's called a POLST. It's Provider Orders for Life-Sustaining Treatment. This green form, if it is signed by a licensed medical provider in the state, is actually medical orders for treatments that you can get in an emergency situation. This form is specifically designed for the community setting, and if you have one, you should put it in a conspicuous place in your home. EMS, ambulance, fire are trained to look for it near your refrigerator, and if you can't put it there, put it on your door. They are actual medical orders. If it's not signed, or if you don't have one, then the emergency services will give you all treatment that's available. And the pulse does not, it's not followed in the hospital. In the hospital, they'll generally follow your advanced healthcare directive. So while every adult should have an advanced healthcare directive, people who should have a post are more those with serious illness or frail, and especially if you're young and you don't want to have excessive or life-sustaining treatment, then you should have a post. But generally, we encourage our kupuna to have one. Next slide. So here's a little table about which items are covered by which one of them. I kind of consider the post to be a short form of the directive, and it's something quick and easy for the emergency services to read. Next slide, please. So everyone should have a healthcare directive. Not everyone needs a post. But with either of those two forms, you should be having conversations with your family. Next slide. Don't wait for a crisis. You cannot get a healthcare directive signed and notarized once somebody loses capacity. They have to have capacity to make decisions in order to get that filed. Next slide, please. And without your legal authority in that document, they may not be able to carry out your wishes. This sentence kind of refers to if there are family members who disagree. Say you have your parent has spouses and or siblings, and then there's also adult children. If there is no documentation and there's a lot of disagreement, there could be a lot of problems. Next slide, please. So both of them name responsible agents that ensure that you will be advocated for, even if you can't speak for yourself. Next slide, please. A couple more quick things I wrote down that I wanted to share. We deal with a lot of kupuna in our practice. We also have a lot of clients who have dementia, and the healthcare directive is typically needed if you don't have capacity to speak for yourself or make your wishes known. Now, a lot of times people can think of some kind of a sudden illness or a tragic accident where you're alive but incapacitated and unable to speak. But you do have cases, people who have dementia, and they go through the stages of dementia, and even in the late stage, you could be still awake and talking and walking, but not have capacity to make your wishes known. So if you have dementia, you can get an advanced healthcare directive signed in the earlier stages when you can still demonstrate capacity.